Yeah, go ahead. I'm all over the internet. It doesn't matter.
We're good to go.
Okay. Hey, sweet. Starts off right. So, first of all, we're all here basically because it's the only track. It's one of the reasons why I love this conference is I don't have to compete with anybody else that's smarter or better. So you're all stuck with me. The topic, NSA wiretaps and why they are legal. So hopefully what you'll gain out of this is the fact that our legal system sucks. Our Constitution is being disregarded. You can write a law today and not have to worry about the effects until the Supreme Court actually rules on it. That is not what our founding fathers intended whenever they wrote the Constitution or our first set of laws. Oh, and by the way, I do touch on some other annoying facts, and I call them facts because they're not laws. They're things like programs in other cities and programs that the government has out there. You can find all the information you want on the internet, and I've actually basically cited all my sources the whole way through. I don't want you thinking that I'm making this crap up because this is really important. So I've cited everything. Sometimes you're going to look at the slide and go, I wish you would have left the citation out of there because that's hard to read. But I just wanted to make sure you understood that I'm not making it up. All right? So, who am I? So basically I'm a husband, all right? Father of 3. Those are my little angels, except for this one. She's older. She's starting to get mean. 20-year Navy vet. 20 years of cryptology. So it was my job to basically ensure secure communications. Started on submarines. Very interesting program there. And then became like a system administrator. Last thing I administered was NT 4.0. So I do not claim to be an administrator anymore. From there, I moved into what we consider the dark side. So I started working for other agencies. Still attached to the Navy the whole time. The Navy does something really weird. The only people that are allowed to work for non-Navy entities are our officer corps. So the enlisted, you just show up and work for an officer, and you're still attached to the Navy. Whereas the officer actually does joint programs. So our enlisted personnel are always considered Navy personnel doing joint operations. Kind of a little bit different. Other services do it differently. I'm a pessimist at heart. The world's going to end today, and that sucks. You know, if I make it to tomorrow, great, but then the world's going to end tomorrow, and that sucks. I'm a constitutionalist. I love all aspects of the Constitution. There's one I love in particular. Anybody want to name that one? Second Amendment. Absolutely. It's actually part of the Bill of Rights. Technically, it's not part of the Constitution, but hey, it is what it is. But my favorite Bill of Rights, articles, amendments, if you want, are the 2nd, the 4th, the 5th, and the 1st. Gotta have the 1st. There's some other ones that are okay, like the 14th, whatever. Equal Protection Clause. Why do we even need it? We're all humans. We should be better than that. But hey, let's make it constitutional. So why are we here? So hopefully you know why we're here. And I would like to thank my inkblot.net friends for allowing me the use of that. There's an alternate version that's probably not best for any audience, so I didn't use that one. Okay, so before we talk about how screwed up we are today, we have to take a little traipse through history, all right? So the very first thing that we had of true importance here in this nation is the U.S. Constitution. And it clearly states that we're supposed to have 3 branches of government, right? You've all heard this. Hopefully you'll start thinking about it again. Because if you're like me, we homeschool, and my wife says, hey, I'm going to Kenya on a mission trip. You've got it for the next 2 weeks. And we're talking about history. And I said, no problem. I was a history major for at least 3 years of college before I switched my major and spent the next 7 trying to get my degree. I've got this. And then you start reading the history book, and you realize 2 things. Number 1, you've forgotten a lot. And number two, it's not necessarily accurate. So keep that in mind. I encourage all of you to read your children's textbooks, at least history. Math has not changed. The interpretation of the Constitution as a living document, that's not a phrase that occurred until the 50s. The Constitution was never viewed as a living, breathing document. It doesn't live, it doesn't breathe, has very stringent rules on how to apply it and how to change it. Those rules are ignored because they're just too difficult. We'd rather have case law to defend the Constitution rather than try to understand what the Constitution says, because they use weird words, like right. So we have the legislative branch, the executive branch, and the judicial branch, right? Nothing new. Legislation branch, right off the bat, it tells you it's split into two bodies, the House and the Senate. Interestingly enough, the Senate used to be appointed by the governors, right? They changed that. They had a constitutional amendment to change that because they said governors are they're on the dole. They're on the take. They're being paid by large corporations, and they're appointing their cronies to the Senate. We need to change that. We're going to make sure these guys are duly elected. So now we don't have that problem. Yes, more spread out. Now you have other, multiple industries paying instead of just a couple. So their purpose, as stated in the Constitution, is to create law, declare war, and there's another one that I didn't put in here. Something about a budget every year. I don't know. The president, his main duties are threefold. Number one, to act as the commander-in-chief, so he's in charge of the military. Well, not really. I'll show you a law a little bit later that becomes very important, called the War Powers Resolution, that really limits the president's role. Number two, he is to act as the chief executive. That means he's in charge of the people that run the government. And then number three, chief diplomat. Judicial branch, body of federal judges, which is disappointing. I don't think our forefathers thought this through. There's very little information in the Constitution on what the judicial branch is responsible for. Now, they do talk about these two things. Number one, establish original jurisdiction, meaning they have jurisdiction over interstate issues. They have jurisdiction over the appellate courts, which, by the way, weren't really mentioned, that we would have an appellate court system. Wasn't mentioned in the Constitution, but we've continuously read that into the Constitution. That's one of the few I think is okay. And then here's something pretty cool. It's not up here. They're responsible for reprimanding diplomats. I don't know why that was an issue. Oh yeah, that's right. The really cool diplomat. Our first one to England. France. Yeah, it was great. So if you don't know about Franklin, read his memoirs. Those are wonderful. His time in France. I'm surprised they funded us for anything, but they thought he was cool. Let's see. Everybody's kind of seen this. I actually pulled this out of a textbook. This is one of the reasons why I encourage you to read your children's history books, is because this is what we're teaching, and it's actually slightly incorrect. So what you'll see is the executive branch. It's the president. He carries out law. That's pretty much true, right? The legislative branch, well, that's Congress. They make laws. Yeah, well, not really without the president's approval. Or if the president vetoes it, they can still make it a law, but it's just really difficult. And then the bottom one, the Supreme Court interprets laws. Not really. The Supreme Court interprets the intent of a law and whether it's constitutional or not. So, I don't know, my wife even says I'm kind of nitpicking that one, but I think that's important to understand. Bill of Rights. What we're going to do from this point on is we're going to go over some of our founding laws, and then some of the asinine laws that have occurred over time. So this is the Fourth Amendment. I put this one in here because it's one of my favorite, and it's kind of key recently. Basically, this says you got to have warrants. If you want to do something to a person and you're part of the government, you have to have a court's approval, supposedly. Title 50 U.S. Code, War Powers Resolution. I talked about this earlier. 1973. What was going on in 1973? Vietnam. Was Vietnam a popular war? Did we like our president for getting us into the Vietnam War? No. So what Congress did was they said, we've got to fix this. There's no way that the president, as commander-in-chief, should be allowed to deploy our troops past 90 days. So right off the bat, we can't really fight a war without Congress's approval. That kind of makes sense because they have to approve war to begin with. The word war is a very funny little word. It's clearly defined in most dictionaries, but it's not clearly defined in law. So as I've been plowing through the 3,000-something pages of documents that I've been reading for this presentation, it became very clear to me that the word law is not very clear. The word war is not very clear. We have this law, also known as FISA, 1978. The purpose of FISA was because the U.S. Army and other agencies were doing collection on U.S. personnel. Now, at that time, it was the responsibility of the FBI to, through the Department of Justice, perform collection activities against U.S. personnel. So what the government wanted to do was say, let's make sure that things like Operation Shamrock, which are in my notes but I don't discuss here, doesn't happen again. So, yeah, I know. If you're the part of the Black Panthers, you know, you can now do whatever you want to do. No, not quite. So what it did was it set up rules for electronic surveillance, physical searches, PIN registers, which will become a very interesting topic here shortly, and reporting requirements. So if you're going to set up collection, you have to report to someone other than your immediate superior. So in the case of National Security Agency, CIA, they report to the president. So they actually have a required reporting mechanism outside of the executive branch. FISA continued. It set up this court. At that time, I think it had 9 judges. It was a body of 9 judges. It said the president can authorize wiretaps of foreign entities. The words foreign entities have been changed recently. Via the Attorney General without a court order. So that gave the Attorney General the ability to write warrants. Bad idea. Who's responsible for writing warrants? The courts, right? There was that separation of duties there. And then the status of wiretaps must be reported to these different committees, one in the House, one in the Senate. One of the things I will tell you is they do receive very detailed reports. Any representative and any senator can go to these meetings. The problem is because they all have a secret clearance right off the bat. As soon as you get elected, you have a secret clearance. The problem is these are top secret reports. You have to get a background check. Some people aren't willing to go through that, right? It's different than a secret background check, a little bit more invasive. And the other thing is anything put out in these meetings cannot be spoken about on the open floor of the Senate or the House of Representatives. So immediately that turns off a lot of people because you can't even discuss budgetary items on the floor. I throw random cartoons in every once in a while because I know you don't want to just hear me speak. So, yeah. Another law, and this was what became, no one realized the importance of this law until recently. So this basically authorized President Bush at the time to go to war with the idea of terrorism. So is this a war? Yeah, a war, terrorism. Is this a war that could end? No, it's an ideology. It's not a nation state. That really sucks. And the way they wrote this, the only way to stop this war is for Congress to enact another law that the president signs. Nobody's willing to do that currently. Let's see, another one. This is our favorite. I'll just condense it. The USA Patriot Act of 2001. This was basically when our world began to change. We had some issues prior to 2001. We really did. Bush got called out on a lot of things he did. One of them was PIN register authorizations, and I'll talk about that a little bit later. And then the other one was the concept of the warrantless wiretap. Well, at that time, every person that makes a major decision in this nation has a lawyer. President has a lawyer. Dernza, director of NSA, has a lawyer. They all have lawyers. The problem is these lawyers, number one, you're not required to research or study constitutional law before you become a constitutional lawyer. Problem. How many people think that they can read and understand the Constitution? It's difficult. Yeah, there are some people out there. I'm a layman. I think I can do a pretty good job of it. I can see things that are wrong and try to correct them. But in order to study and understand what the Constitution means and is about, you have to understand the founders. Start reading their memoirs. Start reading their trying to sell the Constitution and the Bill of Rights to the states that had to ratify it. One of my favorite ones is the Second Amendment to the Constitution, obviously. One of the co-writers of that was Adams. He is actually on record in several state houses explaining what a militia is. And every time he explains it, he says the same thing. A militia is all peoples of these colonies, with a few exceptions, elected officials. So there should be no debate as to what a militia is. The guy that wrote Amendment 2 defined it. We still debate it today. So each person that went out and tried to sell the Bill of Rights and the Constitution to the states, they all basically had the same script that they read from. Do some research. So anyway, sorry, soapbox. Patriot Act, yes sir. Well, they're not part of the militia. We still can't take away their guns. They're just not part of the militia.
Some people could say that. Some people interpret the Second Amendment, well, this is what the
Right.
militia is. So that would include everybody but politics.
Absolutely, that is correct. So the Patriot Act is an extensive law. It's thousands of pages. It has, let's see, there's 9 just that fit on this slide. These are sections. This is part 2, and it's got multiple sections. And some of these should throw some bells and whistles and alarms up right off the bat. So, authority to share electronic wire and oral intercepting information. That one had really good intentions. Prior to September 11th, if the NSA collected something, they could not readily share it with FBI and CIA. So what this meant, what the purpose of this was so they can knock down some of those walls and freely share information. So that sounds like a good one on its face. We'll talk about why it could be bad and well, it is bad. But there's other ones in here. I'm not going to bore you with each one of them because I'm just going to drill down to a couple of them. Every one of these has issues. They just haven't come to light yet. Interception of computer trespasser communications. Horribly written section. Section 217 of Part 2. It is written so that your child could be collected against based on this part of the statute. I mean, it's pathetic. If your child goes on the Webkins and tries to enter in a password that's not theirs, bam, FBI can come knocking on your door if they want it. It's pathetic. So Title II, like I said, we're going to drill into that, and we're going to drill into some of those subparts. The intent, I put the intent on here. Sometimes it is being read that way, sometimes it's not. It made foreign intelligence gathering a focus of the FISA court. Previously, according to the FISA Act, that was the sole purpose of the FISA court, was to collect foreign intelligence. That's no longer true. That's just one of their purposes. So what they've already done is watered down what these judges have to hear in order to do warrants and authorize different things. The government, actually the Department of Justice, no longer had to prove foreign entity was not a U.S. citizen. You have to suspect that they're not a U.S. citizen. And you can be granted collection privileges. Before, you had to prove. Whenever you brought your case before the FISA court, you had to say, I can prove this person's not a U.S. person, not a U.S. citizen, but a U.S. person. There's a difference. And then they could write it. And then you had to show your proof. Now you can just say, I'm pretty sure they're not, but we want more information to figure out if they are or not, and that's okay. Allows any federal judge to issue warrants for terrorism investigations. The FBI used to also have to go to the FISA court depending on where the collection came from. Now the FBI can go to any federal judge and receive a warrant to furthering investigations. That's kind of scary. They don't have to give their sources because the only people with the clearance are the FISA court. Your standard federal judge does not have a security clearance. So they can't be privy to your information and why you need the warrant. It's illegal. Protect telecom companies from lawsuits for participating with the government. That's been in the news a lot lately. Yeah, this family sharing plan. Tell me more about that, Verizon. What can you share with me? Oh, you can share everything because we're going to protect you from lawsuits. Well, that's crap. So specific red flags that I always bring up, there are 3 provisions. The first one allows sneak and peek search warrants. What this says basically is the FBI could label you as a terrorist without provocation. They can say this person is a suspected terrorist. They can enter your premises. They can do a search of your premises to gather intelligence and then turn around and use that intelligence to get an actual search warrant to come back and take it from you. Scary. So you do not have to be notified that a federal government law enforcement officer has been into your house or your business and searching it. That, to me, they should just be slapped. Whoever authorized this law should just be slapped on that one alone. Let's look at the next one. Allows for roving wiretaps. Previous to the Patriot Act, the government had to state which carrier they needed a specific wiretap for. Well, somebody got the bright idea, and it's smart. Once again, a lot of these have good intentions. Terrorists probably aren't going to use Verizon for the next 4 years, right? So they might switch to AT&T at some point. Well, that sucks, because if they switch the carrier, then we've got to go back and ask for another warrant, and that takes time. So what it allows now is you get a single wiretap warrant, and then you're following the person regardless of what carrier they're using. That's a little scary. Number 3, allows FBI orders requiring any documents requested for a terrorism case to be turned over. So the FBI can literally show up to your house and say, we believe that you're enabling terrorism. We want everything that you have, all your computers, your thumb drives, your paperwork, whatever. And then we'll get it back to you, we promise. So, on its face, this law was not an issue because it had a sunset clause. Most of the provisions of Title II of the law were set to expire. Except, Mr. Landrieu, distinguished a representative from Louisiana, said, "Ooh, this is bad. Let's go ahead and vote and extend this for 5 years." And they did it in such a way that not a majority of either the Senate or the House of Representatives were in session at the time, and it just passed through. Great. So for 5 more years, we had this crappy law. So our one saving grace is the court system. Because anytime, from that little example I gave from a textbook, anytime they write a law and the president signs the law, the court has to rule on the law, right? Only if it's challenged. If a bad law is never challenged, it is in force until challenged and ruled on by the Supreme Court. So let's start in 1967, Katz versus the United States. The outcome was the police had to have a wiretap in order to get content. So Katz was a bookie. I think he was in LA. He was calling all over America, taking calls from a phone booth. And the police actually went in. Actually, it was the FBI went in, and because it was cross-state commerce, electronic commerce, they called it at the time. They went in and started recording his phone calls, and he challenged and he won. So that established the need for a warrant for a wiretap that gets content. Smith versus Maryland, 1979, this was really the rule changer. And this ruling from 1979 is what allows our different agencies to do what they do. Basically, Smith was a really bad guy. He beat up this lady a couple of times, broke into her house, raped her, stole a bunch of her stuff. And then that wasn't good enough. Whenever he got home, he started calling her. So the lady told the police, I think I know who he is. So the police installed something called a pin register. Back in the old rotary days, remember you'd go 1. Well, every time it clicked, this pin register actually had a pin on a piece of paper and it would put a mark. And if the mark stopped, hey, that was a 1. If you dialed a 2, it would go, and then they knew it was a 2. So they put this pin register on the telephone company's equipment, and they basically found out this guy was calling her, and then they used that to get a warrant to get into his house, and they had found some of the personal effects they'd stolen from her. So he sued, and he lost. The Supreme Court actually came back and said, no, the government, unlike cats, was not going after content. They were looking at the number he was calling from and the number he was calling to. Oh, and by the way, there's no implied privacy because he's sharing that information with a third party, in this case, the telephone company. So what that said was, you had to have a wiretap for content. You don't have to have a wiretap for something called metadata. In 1979, the Supreme Court defined metadata, and their definition was anything that's not content. Was okay at the time whenever you're dealing with 2 phone numbers. Nowadays, you can get almost as much data from metadata as you can from the content. A lot of times, they don't even look at the content because they don't care. They've got everything they need just from metadata. So at the time, 1979, this was okay. Today, maybe not. More rulings. This is a recent one, Mayfield versus the United States. And this is really where the legal system starts letting us down. So the Circuit Court of Appeals struck down 2 provisions. So this sounds really good, of the amended FISA Act. Because part of the Patriot Act actually went back and amended the FISA Act. So she struck these down. Well then, 2 years later, after the government appealed, she said, you had better arguments this time. Okay. So then they went back to this, they overturned the ruling. They said, yeah, those provisions are actually legal. So now, 2 of those provisions that I said should be, 2 of the 3 glaring red flags are now legal according to our court's judicial system. Kind of scary. Now, it hasn't made it past to the Supreme Court yet. The problem with this and relying on the court system is this. The Supreme Court gets about 10,000 requests per year. They actually hear 75 to 80. So if the Supreme Court did not hear this, which they didn't, then this ruling stands. It is now constitutional. Kind of scary. Some of these are funnier than others. I like it. So is anybody scared so far? Or pissed off or angry? I'm getting a little animated because yes. So let's look at some other constitutional end arounds. Now these are really fun because they're not laws. They're just programs. And programs are there for the people. They're there for, to help us, right? So let's take a look at the first one. Operation TIPS, a domestic intelligence gathering program. Look, NSA and CIA were not involved. Just a small little department called Department of Justice. Basically what they did was it created reporting mechanisms for private citizens with access to or public citizens with access to your private information to report if they see something wrong. The cable guy comes in to install cable. He sees that you're making bombs. He can report you. The letter carrier can say, hey, something smells funny coming out of that house, and they can report you. What's that? Oh, yeah. So the plumber can come in and say, oh, those pipes that I installed, I think he's creating pipe bombs. The last time I saw him, they were in the wall, but hey, he could be creating pipe bombs. He can report you. Luckily, word got out, and this little law called the Homeland Security Act, which created the Department of Homeland Security, it actually specifically got rid of this Operation TIPS. But because it was a program, that's as far as it went. It just said you can no longer have the program. Not a problem. Let's just do another program, right? They specifically named TIPS, so let's just call it something else and allocate resources. So this one's currently active. It's called the Nationwide Suspicious Activity Reporting Initiative. Sounds pretty sexy, doesn't it? So this is the same thing, gathering information regarding behaviors and incidents associated with criminal activity. Now, I should have actually put the word suspected criminal activity, because you don't have to actually have knowledge of someone acting as a criminal. You can suspect them and report them. Oh, the good thing is, though, they created this privacy template that, any official should use, and they fill it out, and they check boxes, and as long as you get more boxes checked than are unchecked, then you're okay, your civil rights have not been violated. Oh, and it came with training, too. They have classes at the National Criminalistics Lab or something like that in McClendon or Herndon, Virginia, somewhere around there. Other convenient facts. This is one of my favorites. The New York City stop and frisk policy. So this one I love. This is an actual page ripped out of the police department's training manual. And it says, if I am a police officer and I see you exhibiting any of these tendencies, I can frisk you. I can put you in handcuffs, not arrest you, but put you in handcuffs, frisk you, and oh, by the way, everything that I find on your person at that time becomes admissible in court because I saw you exhibiting one of these. Well, let's take a look at a couple of them. The first one is spotting a hidden handgun, asymmetrical gait. I was involved in a motorcycle wreck in 2006. After about noon, I start to limp a little bit. My leg really starts to hurt. I have an asymmetrical gait. If I'm in New York City and I'm walking across the street, I can be handcuffed and frisked based on the fact that I've had a motorcycle wreck. Let's see, the upper body shift. Criminals that are carrying handguns are known to be subconscious. And whenever they're walking past a law enforcement officer that they recognize, they tend to shift the gun side away from the officer. If you see this shift, you can now handcuff someone. You can search them. You can use anything on their person against them. If you're running in the rain, people with guns tend to hold their gun while they're running. Never mind that I have my keys in my hoodie. It's a gun until they search it. So, does anybody else see kind of the asininity that is this? Is this not a clear violation of the Constitution? Well, I'll show you in a minute why it's not. Because we had a federal judge, rule. Trespass Affidavit program. This started out in New York also. Thank you, Bloomberg. What he said was, I want owners of businesses and residences to give my police force the power to stop and frisk someone. So all they have to do is put up a handwritten sign that says, if you're on these premises, the law enforcement officers can stop you, frisk you, question you, detain you. That's all they need. At least in Tampa, who's the newest municipality to put this out, they have a sign. So you have to use this specific sign. Thank you, Florida. Whatever. It's a freaking green sign. I can go pick them up. But it's nice. They actually put it in Spanish too, just in case. If you couldn't read the handwritten sign in English, I guess you were screwed. So, what's that? Yes, absolutely. Let's see. Oh, wait a minute. Let me go back to one. So I started looking at some more southern states, because apparently in southern states we love the Constitution more than our northern brothers. Now, even Texas, who is a republic and is very free and open with a lot of their laws, are starting to allow this. Irving was the first one to start. Let's see. More great news. All right. This dude, Floyd, who at the age of 18 was stopped and frisked 68 times for the crime of going home after school between the age of 16 and 18. So 63, 68, I forget the exact number. So whenever he turned 18 and they stopped him and frisked him, he sued. All right. Finally, we have somebody to step up. Well, once he sued, a lot of other people started suing the city of New York. So they actually combined all the cases together and brought it up to the federal appellate court. And this is what the judge said. Page 177 and 181, she wanted to make this very explicit. The city is liable for violation of the 4th and 14th Amendment. You have to pay this kid. Well, now he's an adult. But then, she states again, a remedy in equity is warranted. In other words, once again, pay this kid. And the public interest would not be deserved, by the way, she misspelled deserve, by a permanent injunction. Wait. So the federal judge just said, this is illegal, but I'm not going to stop you from doing it. What the heck? What? These are the people that are supposed to be protecting us from badly written laws. And then, just to put a period on it, at the very end, page 202, she said, however, as previously noted, I am not ordering an end to stop and frisk policies. So it's unconstitutional, but hey, keep doing it. Just don't do it too much. Then I'll fine you. So if you can't read it, it'd be a bummer to be suffocated by your security blanket. That's the surveillance system, right? Everybody sees the government as these peacekeepers and defenders of the faith that are protecting us at all costs, right? So, in conclusion, this is what I want you to at least think about. If you disagree with me, that's fine. My brother-in-law is currently going to NKU Law School. I gave parts of this, well, actually this whole presentation, parts of my full presentation, to some of the professors up there. I had 2 of them respond and say I was an idiot, and I had the other 2 respond and say, absolutely, 100%, you're correct. So even within our law schools, they can't get this stuff right. Support rights organizations like the EFF. If you don't know, the EFF is actually having a public demonstration this month. Sign up. It's this month, right? 26th, yes. Feel free to sign up for it. They're doing a public demonstration, and they're also doing like an online cyber. I hate to use that word, but I got a drink. Cyber demonstration. And I always say this, not the ACLU, and this is personal for me. You can do whatever the heck you want, but here's the reason. Whenever I was at DEF CON, there was a great panel that had the EFF, ACLU, and other organizations who were talking about the Snowden case and freedoms and things of that nature. At the end of it, a colleague of mine who was there also, and myself, we went and spoke to the lawyer for the ACLU. And I said, hey, this is great. You guys are on the bleeding edge whenever it comes to 4th Amendment and 5th Amendment. Wonderful. What is your stance on the 2nd Amendment nationally? And the response was, we don't have a national stance. It's up to the chapter in each state. Wait a minute. So you support the Constitution, just not the 2nd Amendment to the Constitution. And our response was, we support whatever the state head of the ACLU says. Take it with a grain of salt. Do whatever you want. Like I said, they're a really good organization for some amendments and some parts of the Constitution. They don't treat it equally. EFF is really good at treating all constitutional points and the amendments equally. They give equal weight to everything. Talk regularly with your elected officials. My elected official hates me. I write, I call, I fax, which, by the way, if you want to get something done, fax your representative in the House of Representatives. You will get better response, unfortunately, than emailing them. And whenever I spoke to mine, he said it's simple. It actually causes you pain to have to fax something. You can write an email in 5 minutes, not really care about what you wrote, and send it to me. I'll note it. I'll respond to it. If you send something in the mail, I'll get it about 2 months later because I got to go irradiate it off-site. Yeah. And then, have you ever seen that irradiated paper? It's like all nasty looking. Ugh. I wouldn't touch it. I'd rather have sarin than that stuff. But anyway, he said, but if you fax something, number one, it's probably hard to find a fax machine. So I know that you cared about whatever you wrote and you faxed it to him. The other thing he said was, point blank, and I spoke to a senator, not my senator, but a former senator, because I was stationed in D.C. at one point. I used to have coffee with her every other Thursday. It was called tea with Texans, and I would speak to her every chance I could. The senator said, I don't really care about the individual. And the reason is I won by 20,000 votes. One person in the formula that we use to respond doesn't even make a blip. Go talk to your representative. So I walked down the hall, actually different building, walked down the hall, talked to my representative, and he says, dude, I won by 200 votes. If I have one person, one registered voter that tells me something, I'm going to at least inquire about it. I may not talk to you directly, but I'll talk to my staff. I'll have my staff get on the phone, talk to some professionals, and see what's going on. Because 200 is a narrow margin. That could happen overnight. So he says, I say one bad statement, pisses off a bunch of you. All you need is 200 people in your corner, and I'll probably lose my next election. So keep that in mind. I'm not saying that, your senator's a jerk, but it comes down to numbers sometimes. They get in the game because they care. They stay in the game because it's lucrative. And then if you thought that this was decent and you want to know more, especially in the international law area, there was an excellent talk at DerbyCon called How to Fight a War Without Actually Starting One. And this was a kilt-clad warrior from law school up in Indiana, I believe. And Brendan O'Connor. Excellent. You think our simple two-party system with three branches of government is fun to navigate? You should see international law where the word law is not actually a phrase that's represented. Anything that's signed is not a law. Each nation is actually able to carry out whatever they want with regards to that law, even if they signed it. Very few instances where that's not correct. One of them is actual war crimes. Although, once again, that word war is not clearly defined in international law, even worse than our law. So that's a pretty good one. So any questions? All right, well, here's my contact information. Twitter handle, blog, infosecdelta@blogspot.com. I actually put these slides up on or a link to these slides on my blog. So feel free to check it out. And there's my email address.